A legal expert has proposed that by delaying a decision on a motion to dismiss, the judge presiding over Donald Trump's trial for sensitive materials may be working in the former president's favor. Former federal prosecutor and legal analyst Joyce Vance was speaking about the fact that Judge Aileen Cannon has not yet made a decision regarding whether or not the federal case against Trump can be dismissed. This is because Trump's legal team filed a motion claiming that the Presidential Records Act permits him to claim the private documents he took after leaving the White House as his own. On March 14th, Cannon denied another of Trump's petitions for dismissal, arguing that the charges brought forth by special counsel Jack Smith regarding the Espionage Act were unconstitutionally vague in their application to the former president. Cannon stated that any grievances over the legislation might be brought up again in the future in connection with jury instruction briefing, despite her rejection of it. Vance, who has frequently criticized Trump, wrote in her Civil Discourse blog that it was very concerning that Cannon had not yet rejected the contested arguments made by Trump in the Presidential Records Act motion and instead seemed to be preparing the case for a jury trial. It sounded like she was leaning toward dismissing the request throughout the hearing, but not because it has no value, Vance wrote on Sunday. Rather, it appeared that she believed that this motion, similar to the one regarding vagueness, was premature and that the decision would be determined by contested facts that would be resolved through the trial. Because this is so facially wrong, our nation's secrets, generated by the intelligence community, can never be Trump's personal records. The fact that she's pushing matters off to be decided during trial after a jury is impaneled and double jeopardy has attached is very concerning, Vance said. The Fifth Amendment's double jeopardy clause, which prohibits defendants from being retried on the same charges they were found not guilty of, would prevent Smith's office from appealing the decision if both of the arguments presented in the motions are to be brought up in the trial and accepted by the jury. Former Obama administration acting Solicitor General Neal Katyal said that even though Cannon, a Trump appointee, may decide to reject the motions to dismiss arguments, the fact that she convened a full day of hearings to consider their merits in the first place may ultimately aid Trump in his efforts to postpone the federal trial. On March 14th, the day of the hearing, Katyal spoke with MSNBC and said that Cannon's verdict in favor of Smith's office was only a partial success. She likened this to what would happen if the Supreme Court rules that Trump cannot use total immunity as a defense in order to have his federal election obstruction case dismissed. There is no possibility that Trump will prevail and that the court will rule that he is immune from any consequences. However, the Supreme Court decided to postpone his trial for the accusations he faces until after the election, Katyal stated. Judge Cannon is also doing what I fear: she keeps kicking the can down the road. All you need to know is that she held a full-day hearing on these two fictitious concerns today. Donald Trump's arguments are only worthy of a quick denial and an eye roll. In response to accusations that he unlawfully kept confidential documents after leaving the White House in January 2021 and thwarted federal efforts to obtain them, Trump entered a not guilty plea to 40 charges. Currently set for May 20th, the trial is anticipated to begin later due to Cannon's actions. Furthermore, Fani Willis may file an appeal against the ruling granting her permission to pursue Donald Trump's legal defense in his Georgia election case. During her prosecution of the former president and 18 other people charged in a 41-count indictment of attempting to reverse his Georgia 2020 election loss, Willis, the district attorney for Fulton County, was rewarded with a victory last week. Judge Scott McAfee declared Friday after an ethics hearing that he would not remove Willis from the case. This decision was made in response to claims made by co-defendant Michael Roman, a former Trump staffer, that Willis was having an affair with Nathan Wade, the special prosecutor she hired for the high-profile case, and that the two were benefiting from taxpayer funds. She chose to accept Wade's resignation because he offered her the choice to remove herself or Wade, the special prosecutor she hired for the case. The Republican nominee for president, Donald Trump, has consistently claimed the prosecution is a political witch hunt and entered not guilty pleas to each of the 13 allegations brought against him.